Personhood, reproductive choice, and family formation, tax traps and opportunities in the post-Dobbs era. We have a great group of panelists speaking today on fetal personhood and the various tax ramifications of the Dobbs decision. Before I get started on the substance of the panel, I want to address a few housekeeping matters. This webinar will be recorded. No CLE is being offered. And this webinar is being co-sponsored by the ABA Tax Section, the Section of Civil Rights and Social Justice, and the Women in Tax Forum. Both the ABA Tax Section and the Women in Tax Forum offer free programs like this for members all of the time. I highly encourage everyone who is not a member of either or both to join. The link to joining the ABA Tax Section should be available in the chat box. For any JD and LLM students on the call, joining the tax section is free. It's a great way to meet those who work in the tax practice, and it's a great way to get a better understanding of what tax looks like, which, as you will find out today, also includes the Dobbs decision. So as I'm sure most of you are aware, the Supreme Court handed down the decision in Dobbs v. Jackson Women's Health Organization earlier this year. The court ruled that the Constitution does not confer a right to abortion, that Roe v. Wade and Planned Parenthood of Southeastern Pennsylvania versus Casey are overruled, and that the authority to regulate abortion is returned to the people and their elected representatives, so essentially to the states. I don't think the impact of this decision on the legal industry, but many of our lives, can truly be understated. It's had an enormous impact in ways that many of us both expected and ways that we didn't expect. What may surprise many individuals is that the Dobbs decision also implicates tax in a variety of unexpected ways. Today, we are very lucky to have three phenomenal panelists that will discuss and consider the various tax and fetal personhood implications of the Dobbs decision. First, we have Professor Carlos Chapman. Professor Chapman is a professor of law at Washington and Lee University School of Law. She teaches business law, commercial law, and various ethics courses. Her scholarship, which focuses on corporate law, ethics, and civil procedure, also integrates an interplay of business entities, government, and natural persons. Unfortunately, Professor Chapman will not be able to appear in person, but she's graciously agreed to record her segment of the webinar. We also have Professor Catherine Katie Pratt. Professor Pratt is a professor of law at LMU Loyola School of Law in Los Angeles. She teaches tax and business law courses and writes on various federal income tax issues, including the tax treatment of medical reproductive expenses. Finally, we have Erin M. Sweeney, who is a partner at DLA Piper. She advises on all facets of employee benefits, including Dobbs-related issues, ACA compliance, HIPAA matters generally, and more specifically in the context of COVID-19 considerations, welfare benefit claims, COBRA, DOL audits and investigations, and employee benefit plan administration, including the application of Title I of ERISA to benefit plans. Erin is very, very busy. So we'll go ahead and get started on Professor Chapman's segment of the webinar today. And we'll go ahead and get the recording going. If we could.
Hello, everyone. I am Professor Carlos Chapman, and I'm an associate professor at Washington and Lee's Law School. Thank you for inviting me here today. I am sorry that I was not able to join you in person, but I'm probably on a flight right now that I originally was not planning to have to take today. So I'm thankful that... Hello, everyone. I am Professor Carlos Chapman, and I'm an associate professor at Washington and Lee's Law School. Thank you for inviting me here today. I am sorry that I was not able to join you in person, but I'm probably on a flight right now that I originally was not planning to have to take today. So I'm thankful that technology enables me to record this presentation in advance. My portion of the conversation will be about personhood, and I will talk about some of my current works in progress that I'm loosely calling a slippery slope of fetal personhood, and it builds on the work I've done on personhood generally, primarily with a focus on corporate personhood. But for the last few years or so, as Dobbs and other cases have worked their way through the court, I have begun to talk about fetal personhood. So I'm excited to share my thoughts and theories with you today. Now, as I said, I typically write about corporate personhood, but I've always believed that all personhood should follow the same analysis. My fetal personhood work, or the public facing part of my fetal personhood work, began with a tweet that I sent in May of 2019. I like to emphasize the date, May 2019, because people often think I wrote this tweet post-Dobbs, or that I wrote it after, other various and sundry fetal personhood statutes came into the news, but it is a 3-year-old tweet that has proven to be evergreen. So here's what the tweet says. If a fetus is a person at 6 weeks pregnant, is that when the child support starts? Is that also when you can't deport the mother because she's carrying a U.S. citizen? Can I insure a 6-week fetus and collect if I miscarry? Just figure if we're going here, we should go all in. Now, what is interesting about this tweet is I sent it walking my now unfortunately deceased dog Napoleon one morning. It was actually graduation weekend. I did not expect this tweet to go viral. I was just kind of waxing poetic one morning as I was reading about, I believe it was Alabama's personhood bill, and I could see the personhood litigation or personhood bills becoming a collateral attack on the right to choose. It went viral at a time when people were hearing about fetal heartbeat bills and getting anxious about whether personhood alone would be what overturned Roe. We saw from Dobbs that wasn't even necessary. It was simply a 15-week abortion ban. Now, what is interesting about the tweet is, again, I didn't expect it to go viral at all. I was making a tongue-in-cheek argument based on the 14th Amendment and my personhood research, and I honestly thought only law professors would get it, or lawyers. But for some reason, it struck a nerve with a lot of unexpected audiences. In addition to the 600,000 or so people who have liked it on Twitter, it's been reposted and screenshot on Facebook and Instagram by feminist organizations and individuals. A lot of famous people have retweeted it. Friends have reported it was strange to have their friends resharing it. And so I get the, my friend from high school retweeted your tweet a lot. And it also has been the subject of a meme. So the image on this slide is a meme that I think Occupy Democrats did. I kind of just have Google image search for myself, Google alerts set on the words of the tweet so I can keep track of what's happening. But what is also interesting is it shows how words can get to the same conclusion, even in contexts that you don't expect. I've had libertarians send me favorable notes about ending government control of the welfare state and thanking me for standing up for libertarian rights. I am not a libertarian. I've had conservatives message me to thank me for exposing how immigrants might go from using anchor babies to anchor fetuses. Again, not my intention. And I've had messages from scientists and philosophers and rabbis and, physicists and gynecologists and all kinds of people. And of course, both sides of the abortion movement have decided this tweet is for them. Now, post-Dobbs, as my tweet from 3 years ago, has become a question we should all consider, given the actions that states have taken. I've been asked how these questions could impact the law, and we've had 2 instances so far where states have concretely declared a fetus to be a person. The infamous HOV lane case, which I think is what led to me being on NPR about this, where a pregnant woman was able to get out of a ticket by claiming there were 2 people in the car. And then we have Georgia declaring that fetuses can be claimed on state income taxes as dependents. We have not had any acknowledgement from the federal government of what this tweet means. So let's get into how I analyze fetuses using my corporate framework. When I think about the outcome of Dobbs and its collateral consequences, my mind goes to an unexpected place. Personhood, and particularly corporate personhood. And in thinking about personhood generally, I think about comparative personhood. This citation, my article, Corporate Personhood Two-Step, is the framework I use for analyzing all personhood. So in my conception of personhood, the personhood of humans isn't defined by the state. And I should say humans who are born. It is preordained. We are born people. We are granted citizenship by states. Therefore, the rights that flow from mere personhood alone are not granted. Instead, when the state is choosing to stop oppressing marginalized persons in acknowledgement of their human and their personhood rights and autonomy, it is mere acknowledgement. So when I think about rights and, legislation prior to a case like Roe or prior to the passage of Title VII, those things were a disregard of autonomy and personhood, as opposed to them being an acknowledgement or a granting of something. So in other words, in my framework, the state gives us as human beings nothing. They are instead infringing, disregarding, and oppressing according to the whims of privileged persons when they do not give rights. So in my framework, states' rights for human beings makes no sense. The trend should be towards full autonomy and freedom, not towards letting any people decide exactly how free some people should be. In my framework, artificial entities are different, and they are analyzed according to my two steps. A corporation, a partnership, or LLC doesn't exist without state definitions and acknowledgments. They must meet all requirements for formation and all requirements for survival. It makes perfect sense for a state to restrict the rights of a corporation because the corporation is a new separate person who would not exist but for a grant from the state. So when I define corporations and corporate rights, I take my two-step approach. I propose that corporations are both artificial entities, creatures of the state that would not exist without a grant of a charter by a state actor, and real entities that exist as standalone entities capable of suing, being sued, being legally bound to contracts, committing crimes and frauds, and other legal rights embodied in legal personhoods. So the real question is, how will fetuses be evaluated in this framework? The evaluation of fetuses will depend on how those legislating and interpreting them view them. Are they an other? Are they like human beings that have been marginalized historically? Or are they an extension of the legislators, much like the corporation, and thus given, what is many view as superior status? So I tend to believe that fetuses will be treated as precious extensions of maleness, just as other artificial entities have been when they can be used to benefit this power structure. So it leaves me with a pressing inquiry. Do fetal personhood bills redefine where personhood begins for all human beings, changing the meaning of the 14th Amendment due process and citizenship mandates for persons, quote unquote, born in the United States? Or are they new artificial entities like a corporation reliant on states for definitions and rights? Here's why the answer to that question matters and why it is different. Let's take option one. If we're changing what it means to be born, and ultimately what it means to be a person, a living, breathing, natural person, the possible outcomes of question one are those in my original tweet. When we change what it means to be born That means suddenly every fetus at the point of a heartbeat or whatever other point in time that a state chooses has full 14th Amendment rights that are enforceable, not just against the mother to force her to remain pregnant, but against every aspect of the government. Further, the whole point of the 14th Amendment is that states do not get to define people. We no longer have Virginia saying that, a person is not a Black person or person of African descent, or a person is not someone with one Black grandparent, and all the various ways that states were defining people. Instead, we've got person is born. So if we are taking the first approach of redefining born, I believe that is an immediate constitutional challenge unless states with personhood laws are actually doing option 2. Option 2, and this is why John Marshall is on this slide, option 2 is creating a new artificial entity. Artificial entities can be hybrids in the ways that corporations are hybrids. In my personhood work, I've explained that corporations are both artificial entities that don't come into existence until the state says so, and unless they meet all the state rules. But once they are formed and meet those requirements, they're as real as you or I. I also have a children's book that explains this called Companies Are People Too. So that states can put mandates on corporations at formation and operations, but they can't go back on their deal once they've made them a person. Now, where does this concept come from? This idea comes from Chief Justice John Marshall's opinion in a 200-plus-year-old case called Dartmouth College v. Woodward. And it declares it to be so. It declares that when states give personhood, they can't take it away. So when we apply this concept to fetal personhood, if states intend them to be artificial entities, that would not change anyone else's personhood except for the mother who is forced to carry the fetus. Each state could define the personhood of this new artificial entity, then other states would have to acknowledge their reality after it's formed in the same way that full faith and credit mandates that, we acknowledge a corporation once it's formed in Delaware, but a state would not be required to define fetuses for themselves. This framing presents other constitutional questions. Like the other federal questions in my tweet, does it apply to artificial persons that are future humans or not? It is a quagmire that I have not had to unravel yet because unfortunately, nobody seems to really care or realize this is a problem. No state to date has told us which option they are taking. No state has told us whether they are redefining born or whether they are creating a new artificial entity like a corporation that stands alone state by state. Now to close, I'd like to go through a few of the scenarios I listed in the tweet and just explain why they matter in the context of this presentation and in the context of the other things that folks will be talking about today. Each of these issues, child support, deportation, criminal detention, Social Security number, dependent status, and the census is an outlier. But what all of these things have in common is we've got state by state definitions of these things, right? Every state permits the custodial parent, whoever has primary physical custody for the day-to-day care, to receive child support from the non-custodial parent. With deportation and immigration, the 14th Amendment defines citizenship as born. And if we are changing this definition of born state by state, does that give us state by state definitions for deportation? Because how can you deport the U.S. citizen that resides inside of a non-citizen? But when it comes to Social Security numbers and dependent status, if we are changing these definitions, how do we reconcile a state by state definition of when life begins with a federal tax code and the various state income tax codes, right? If states declare that personhood begins at some point arbitrarily, some artificial point of time before birth, is the federal government going to be giving out Social Security numbers so that people can also claim them on their federal taxes? What do we do about these things? And then when we think about the census, which is taken every 10 years, if we are counting fetuses in some states but not others, how does that skew representation? And so while this all started out as a tongue-in-cheek kind of tweet, in the current context, it can have many, many collateral consequences. I'd like to thank you all for your time and thank you for the opportunity. Again, I apologize for not being able to be live and in person or virtually live with you today. Feel free to email me or DM me on social media if you have questions and comments.
That was great to hear from Carlos Chapman. I didn't get a chance to mention this initially, but we encourage you to ask questions in the chat box for our panelists. Any questions you have on the topics they've discussed, we'd love to hear from you. Next, we will proceed with Katie Pratt, who's going to discuss the federal income tax aspects and state income tax aspects of Dobbs. Go right ahead.
Thank you, Brittany, and thank you for inviting me to participate in the panel today. As we tax professors like to say, tax touches everything. So we do need to talk about some tax implications of the Dobbs decision. Today, I'll discuss three topics. I'll speak just briefly about whether the definition for tax purposes of dependent potentially has changed because of Dobbs. I'll also speak briefly about some longer term implications of Dobbs for access to family formation, but primarily I'm going to be speaking about my second topic, and that is the tax treatment of family formation medical expenses, including expenses for egg donation, IVF, and surrogacy. Okay, please advance the slide. Thank you. So I'll start with the definition of dependent, and this is sort of in the weeds here. I know not everyone here is a tax lawyer, but I've included this in the slides because technically you need to know this information. The tax definition of dependent is in Internal Revenue Code section 152, and it tells us that the term of art, the defined term dependent, means either 1, a qualifying child, or 2, a qualifying relative. The requirements for each is fairly similar, but I'll note the difference here. For an individual, for purposes of our discussion, potentially a fetus, to be a qualifying child, the individual, the fetus, unborn child, would have to have the same principal place of abode as the taxpayer, and the taxpayer would have to be supporting the child, the unborn child. So the place where this might be problematic is if an individual or a married couple is using a surrogate, and the surrogate lives someplace other than the taxpayers trying to claim the deduction. In that case, the taxpayers would need to invoke the qualifying relative definition on the next slide. See that? Thank you. So there's a relationship test again, but for this requirement, you can either meet the relationship test or have the same principal place of abode as the taxpayer, plus a support test. So in the case of surrogacy, the fallback position would be qualifying relative if the taxpayer, either an individual taxpayer or married taxpayers, are going to gestate the child, then it would be easier to meet the qualifying child definition. So that's all I'll say at this point about the federal definition of dependent for tax purposes. Please advance the slide. So that's existing law. Now, what does Dobbs potentially do to that? Prior to Dobbs, the tax law very clearly ignored the existence of a fetus until birth. So we have cases in which parents tried to claim a, quote, dependent prior to the time the child was born alive, and the IRS consistently has denied those deductions, and courts have upheld the disallowance of the deduction. Similarly, where a child is adopted at birth, adoptive parents have tried to claim medical expenses incurred prior to the birth, claiming that the unborn child is the intended parent's dependent, and courts again have denied that deduction. So pre-Dobbs, the tax law uniformly has ignored the existence of a fetus until live birth. Please advance the slide. So how does Dobbs change that? Well, the state fetal personhood statutes might change the outcome of these administrative practices and cases by characterizing an embryo or fetus as an unborn child and possibly as a dependent for tax purposes under the statutory definition I referred to earlier. And I want to note going forward for the rest of our discussion that various state statutes might define fetal personhood differently. So they might define fetal personhood as beginning at conception. They might define it as the transition from embryo to fetus, or they might define personhood as starting at another stage of embryonic development. For example, the so-called fetal heartbeat, the electrical current in effect. Please advance the slide. So for our purposes today, I'll just refer to fetal or embryonic unborn child, noting that state statutes may differ slightly in when they statutorily provide that personhood begins. Right, so there are various federal income tax benefits provided to taxpayers with dependents. There are a whole assorted group of dependents. One might be refundable or partially refundable credits, like the child tax credit. A filing status can depend on whether a taxpayer has a dependent child or not. But for the rest of my time, I'm going to be really focusing on the tax benefits for taxpayers who incur medical care expenses. Please advance the slide. What are the federal tax benefits for the cost of medical care? Well, the starting point is Section 213, which allows taxpayers a deduction for unreimbursed expenses above a certain floor of adjusted gross income for, defined term of art, medical care, air quotes, of the taxpayer, his spouse, or a dependent. And we'll define the term medical care under Section 213. That definition is applied for the other two tax benefits provided on this slide. So a second benefit potentially is deduction of contributions to a health savings account and exclusion of distributions from a health savings account to pay medical care expenses. Also, taxpayers are not taxed on reimbursement from flexible spending accounts that might be maintained by an employer, as long as the expenses were incurred for quote unquote medical care. Next slide, please. Section 213 D1A provides the main part of the definition of medical care for federal tax purposes. And I'll refer to two separate prongs or parts of this definition. So 213 tells us medical care, the defined term, means amount paid, one, for the diagnosis, cure, mitigation, treatment, or prevention of, air quotes, defined term, disease, or for the purpose of affecting any structure or function of the body of the taxpayer's spouse, or a dependent. And just globally, as we sort of dig into this definition, I'll note that the baseline in Treasury regulations and in case law is normal functioning. Please advance the slide. All right, so I'll tell you a little bit about each of these two prongs. First, the disease prong is construed very, very broadly. So disease is way broader than it sounds. It includes physical illness, mental illness, conditions, congenital abnormalities, structural abnormalities, traumatic injuries, basically any condition for which people seek care of a medical professional. Also, it's important to note that under Treasury regulations and cases, taxpayers can deduct as medical care expenses for a substitute for normal functioning. Sometimes the expense is what I refer to as an inherently medical expense. For example, a taxpayer pays the medical expenses of a potential kidney donor. The taxpayer who needs the kidney can deduct the expenses that taxpayer pays to have medical procedures performed on a different human being who is not the taxpayer's dependent under the substitute for normal functioning argument. So that's for inherently medical expenses. Even non-medical costs can qualify under the substitute for normal functioning argument. An example is a taxpayer can deduct the cost of a seeing eye dog for a blind dependent. So that's the disease prong. Please advance the slide. Important to note for the structure or function prong of the definition that cosmetic surgery is not medical care. I've given you a little information on that, not particularly relevant for our discussion today. More relevant for our discussion is that Treasury regulations going back 70 years have stated that obstetric care is medical care under the structure or function prong. And again, it's important to note that when we talk about structure or function of, quote, the body, we mean the body of the taxpayer's spouse, or the taxpayer's dependent. This is important in the context of collaborative or assisted reproductive technologies. Please advance the slide. So now I'm going to talk about the deductions primarily for medical care in the context of assisted reproductive technology. So I'm thinking primarily about egg donation, IVF, and surrogacy and related expenses. And I have to divide the analysis into three different groups of taxpayers. First, infertile, medically infertile, different sex married couples. Secondly, single men and male same-sex married couples. Third, single women and female same-sex married couples. Now, why would I divide the world of taxpayers in that way? Because administrative pronouncements and case law have divided taxpayers in that way. I challenge those classifications in articles I've written, but that's a subject for another day. So today I'm just trying to tell you what the law is and how Dobbs might affect that law. So I need to follow the classifications that exist under current law. So we're going to start with infertile, married, different sex married couples. The IRS has allowed deductions for the cost of egg donation and IVF as medical care. Publication 502 for decades has provided that taxpayers can deduct the cost of sperm storage and in vitro fertilization, quote, to overcome an inability to have children, close quote. In a private letter ruling issued to an individual taxpayer, the IRS also allowed a deduction for the cost of egg donation for a different sex married couple with a history of medical infertility. But these IRS pronouncements do not bind the IRS. So take this history with a grain of salt. Professor Tony Infante notes that the tax law aggregates the bodies of a married different sex married couple, a husband and a wife. So medical treatment of not only the husband and wife, but all of their, in effect, reproductive products are just sort of aggregated with the husband and wife. So the tax law does not recognize pre-Dobbs the independent status or personhood of sperms, eggs, embryos, fetus, but it does recognize medical processes performed on a husband or wife as medical processes and expenses as medical care. Please advance the slide. Okay, now the IRS consistently has taken the position that surrogacy costs are not deductible medical care. And I should note that surrogacy, sort of from an ethical or moral perspective, is considered to be the most problematic of assisted reproductive technologies. And states vary in the degree of enforcement of surrogacy contracts. So we start from the perspective of surrogacy being regarded more skeptically than IVF and egg donation. So the IRS consistently says surrogacy costs are not medical care. But in a case, the Sedgwick case, the taxpayers won and were allowed their surrogacy expenses as medical care. In that case, there was a long history of medical infertility, but the case resulted in no reported decision because the IRS settled the case to avoid an adverse decision. So there's no authority as a result of the Sedgwick case. And my argument is that surrogacy costs should be treated as medical care under the substitute for normal functioning argument. The IRS might counter that kidney function is essential. Having children is not essential for life, but non-tax cases and administrative practices indicate that reproduction is an essential function if a person wants to have children. Please advance the slide. Okay, what might Dobbs and state fetal personhood statutes have changed? And so I'm going to be repeating what is on this slide 3 different times for the taxpayers in these different status groups based on case law and administrative pronouncements. Fetal state personhood statutes might strengthen the argument for treating surrogacy expenses as medical care because the fetal personhood law would treat an unborn child as a person. Therefore, based on our earlier discussion, the unborn child might be treated as the taxpayer's dependent, and therefore the medical care of the fetus or embryo might qualify for tax benefits of medical care. Please advance the slide. Okay, the next category of taxpayers is single men and male same-sex couples. The IRS, again, consistently has taken the position that male taxpayers, whether single or male same-sex married couples, are not allowed to deduct the cost of egg donation, IVF, or surrogacy. And you might say, wait a second, what about publication 502 that says you can deduct the cost of medical care to overcome your inability to have children? And the IRS basically said, that doesn't apply to you, single individuals or same-sex married couples. We meant different sex married couples. So that's the IRS position. There was a recent private letter ruling from 2021. Male same-sex spouses tried to deduct the cost of IVF and surrogacy, and the genetic material was the sperm from one spouse and the egg from the other spouse's sister. So going back to that definition of child, it would be relevant that, sort of the extended relationships include the child of the taxpayer's sibling, sister here. In this private letter ruling, the IRS says no deductions for anything other than what the IRS regards as sort of the male reproductive functioning, the medical process performed on sperm, extraction of the sperm and freezing of the sperm, which is very, very inexpensive, no deduction for the big ticket items. And where does the service get this distinction between female and male functions? From the Morrissey case, which is one of the 3 cases listed here, holding that men are not allowed deductions for the expenses of assisted reproductive technologies. Please advance the slide. So the rationale of Morrissey is the court focuses very, very heavily on, quote, natural, close quote, quote, biological, close quote, reproductive functioning. And the majority opinion says there are male functions and there are female functions of reproduction. The court says that the male function is limited to producing sperm and ejaculating. There's nothing else involved in the male function. All other reproductive functioning is female functions. So the court said that men might be able to deduct medical expenses of providing sperm, freezing sperm, if they're biologically, hindered in some way from performing that reproductive function. But men cannot deduct the costs for any, quote, female, close quote, functions, including egg donation, IVF, and surrogacy. I have counter arguments. Those are in my articles. Topic for another day. Please advance the slide. All right. So Mr. Morrissey argued in his case that the medical care was performed on his body because it was his sperm and then the genetic material from his sperm that became the embryo and the fetus. The court flatly rejected that argument, saying that the big processes, the egg donation, IVF, and surrogacy processes were performed on and affected the structure or function of the female egg donors and surrogates, not Mr. Morrissey. Next slide, please. So, post-Dobbs. Well, now Mr. Morrissey's argument has a better chance of succeeding because under fetal personhood laws, the embryo or fetus, depending on the wording of the state personhood statute, is an unborn child. So the expenses that a taxpayer incurs for care of the embryo, say we have an in vitro, a fertilized egg, and it's starting to divide and it needs to be implanted. Well, then under a conception is the start of personhood, then the single multi-cell being, unborn being, could potentially be a dependent. So that would bolster the argument for a single man or male same-sex married couple to deduct the cost of IVF and surrogacy, although not really egg donation. Okay, next slide, please. Then our final group of taxpayers are single women and female same-sex married couples. So after Morrissey, the case law indicates that women without a husband cannot deduct the cost of a sperm donor because that's, quote, male functioning. So they don't get to deduct that. But otherwise, the analysis seems to be the same as for married different sex couple. But there is no case law. There are no administrative pronouncements to directly support deductions for art expenses for single women or female same-sex married couples. If the woman or the couple will gestate their own child, then under the definition, it's extremely straightforward. All the processes are performed to change the structure or function of the female taxpayer's body. But surrogacy, if a woman cannot gestate her own child, the IRS would disallow the expenses. I argue those should be deductible, but of course, that's not legal advice. You can read my articles if you want to learn more. Please advance the slide. I'm almost done. So same reasoning, the fetal personhood statutes could strengthen the argument for treating surrogacy expenses as medical care. If the couple will gestate their own child, they don't need fetal personhood to claim the medical expense deduction. Please advance the slide. Okay, hate to end on a downer, but here's where we are. If the current unprecedented legal trajectory continues, assisted reproductive technologies might be much more heavily regulated. They might even be banned. Access to arts might be limited to different sex married couples with a history of medical infertility. Access to adoption might be limited to different sex married couples. And unfortunately, Obergefell and Windsor might be overruled. So here's a little bit of non-legal advice. If you in the audience plan to form a family using arts, get going. If your clients plan to form a family using arts, tell them to get going. Warmest wishes and good luck to anyone trying to form a family. And I turn it over to Erin.
Thank you, Katie. Now we'll have Erin present on ERISA and other employee benefits. Erin, I think you might be muted.
So in this section, we're going to talk about how can employers assist their employees who are trying to obtain reproductive services, even if those employees live in a state where reproductive services are restricted. And not only how can they assist their employees to obtain these reproductive services, but also how can employers act to protect the data associated with these employees receiving the reproductive services. So let me just drill down here a little bit. I had a whole number of clients who reached out to me right from the moment that the Dobbs decision was leaked, and certainly after the decision and including through today, where clients wanted to know, okay, well, how do we make sure that we provide access to reproductive services to our employees? And really the first item that I wanted to talk about is the benefit of ERISA preemption. And ERISA is the statute, the Employee Retirement Income Security Act. ERISA is the statute that governs all medical benefits and retirement benefits. And the reason why ERISA preemption has been so important to employers who are trying to protect the reproductive services for their employees is that ERISA acts like a shield. And what ERISA says is that ERISA preempts or strikes down or overrules essentially any state law. And that would be all of the civil laws. So like the laws that are non-criminal. And so what employers have been trying to take the position is to say, well, how can we find a way to provide reproductive services to our employees? And one significant way to provide that benefit is through your ERISA plan, because under the current case law, ERISA, if you have a medical plan, that would preempt these state laws. I mean, it's a tougher question on the criminal side, because what ERISA provides is that ERISA preempts those statutes that are criminal other than generally applicable criminal statutes. And what we found under the courts have held is that every time that the legislature has tried to really involve an employee benefit plan or reference an employee benefit plan, the courts have typically held that that those laws are preempted by ERISA. And so what employers rush to do is, okay, let's put these benefits under our ERISA plan. And really the easiest place to do this is the self-insured plan. And again, it's not a slam dunk, because I do have clients that have said, well, what happens if one of these aggressive attorney generals decides to bring a lawsuit and they are trying to go after a company that provides these self-insured benefits? We don't know what's going to happen here. I mean, it's sometime in the next 5 years, there's going to be litigation. The federal government has said they're going to sue the states. I mean, there's going to be a lot of litigation over this. But in the self-insured arena, the carrier or the third-party administrator really takes a lot of the direction from the employers. And what I found, though, originally was a lot of the carriers, third-party administrators, which are the same players on the fully insured side of the house, which is, United Healthcare, Aetna, Anthem. What they started out with in their proposals was separating out the reproductive services benefit from other types of travel and lodging benefits that were already provided. And what I advise clients to say is, no, we want this all to be together. Like, we don't want to really put a target on the back of our plan participants and say, hey, wait a minute, they're taking advantage of the reproductive services benefit. But take a look at your plan already. It probably already provides travel and lodging benefits for transplant, bariatric surgery, other types of arrangements. So let's put it together. And I had some carriers say, well, this might require a lot of back and forth between the insurance carrier, the TPA, and the employer. And I said, well, it might require some back and forth, but in this situation, has there ever been a time when receiving a medical benefit could potentially be creating criminal liability for the plan participant, not to mention potential criminal liability for the corporation, and the corporate officers or the HR department, at least as some of these aggressive attorney generals have indicated, for just providing the travel lodging benefit. The last point I wanted to mention on the self-insured slide is just that I did have a bunch of clients who were talking about, they started out where the TPAs or the carriers would say, well, we want to make this an in-network only benefit, but backed off of that pretty quickly, because the idea here is to make sure that this benefit is available to participants. And for some participants, they want to utilize Planned Parenthood, for example, which is not an in-network benefit under most plans. And so what we're seeing here generally is a little bit of the best practice is to provide this benefit both in network and out of network. So next slide, please. The plans that are having a more difficulty are the fully insured plans. And these are the plans where, the State Department of Insurance approves the plan. And so what happens is in the spring of every year, the State Department of Insurance provides for a particular product to be reviewed over the spring and over the summer. And then ultimately those products are approved for sale for 1/1 of the following year. And so what we found is that even in some of the states that are pretty aggressive on these issues, we really aren't seeing that the State Department of Insurance are willing to allow for amendments to fully insured plans that are in play right now. We are hearing that some states are likely to have a travel lodging benefit for 23, but in the meantime, the question is, what can an employer do? And the one well-traveled path that we're seeing a lot of traction is health reimbursement accounts, because again, a health reimbursement account can also take advantage, hopefully, of ERISA preemption. We've seen less uptake in flexible spending or employee assistance programs. These vendors have not really been interested in providing this benefit. But another area where a lot of employers have landed is the standalone program. Next slide, please. And the question here with the standalone benefits is that this is something that the employer is providing that our regulators could consider to be medical care. So it could be considered to be an ERISA covered plan. And really a non-compliant ERISA covered plan because it doesn't file tax returns, it doesn't satisfy the Affordable Care Act provisions. And so, I have warned clients that this may be a concern, although I have also reached out, had some conversations with the Department of Labor about, would it be possible to get a non-enforcement policy with respect to these kind of programs? And so I think some key considerations here in talking about a standalone program is to focus in on not whether or not the conduct is illegal in the state where the participant is from, but to very much focus on that these are lawful benefits available in the location where the participant is. And I say this because some of the draft language that I've seen in this area, it talks about if you can't, if it's not legal in your state, and I warn people, we don't want language in here that's, in order to get this benefit, that we're saying that it's not legal, because again, that puts a target on the back of our plan participant. It potentially creates liability for our corporation that's providing the benefit. Some employers do limit this to the closest suitable facility, so that they'll say that they're trying to create some parameters so that people don't take a trip to Hawaii to have to obtain these services. But then I've also had clients that said, hey, wait a minute, we want people to be comfortable, we want our talent to be comfortable, so we want, if people live in a state where reproductive services are restricted and they feel more comfortable flying to California to be with their family, we want them to go where they feel comfortable. Would also add that an important consideration here is that most employers have wanted to have this be a payment as opposed to reimbursement, because they don't want their employees to be getting receipts They don't want, they don't want the people having to process for privacy reasons, their own employees processing each other employees' reimbursements. And also, there's the consideration that, some employers have said that their employees have, moral reasons. They say that, I don't feel I could process these kind of receipts because to me, this is like taking a life. And so what we've seen is employers have moved from the reimbursement idea to payments, and it's treated as a taxable benefit. So next slide, please. And then I just wanted to take a couple minutes to just talk about the other piece of this, which is how do employers protect this information? And one item that I always tell employers is that you need to take a very careful look at the agreement that you have with your health insurance carrier or your TPA. Because while these laws are primarily focused on medical service providers that are making the reproductive services available, and then as a secondary matter, then perhaps the insurance carriers and the third-party administrators, but right below that is employers that are providing this travel and lodging benefit. So what I say to employers is take a look at your provisions now. Make sure that right now your agreement probably just says that you get notice if there's a subpoena. But I have advised that if you want to manage this subpoena process, then you ought to add language into your agreement with your carrier explaining, that you want a right of consent. You can take charge of this subpoena process, and unless you defer it to the carrier or the TPA. And I would also note that most of the time, for those of you that practice in the criminal area, recognize that most subpoenas are confidential. And so I've also put in language that indicates that, well, if you get language that requires that the carrier keep this confidential from the employer, that the carrier still has to take certain actions, including move to fully quash the subpoena, also move, if that's not successful, to de-identify the participant data. And then third, that they need to take every possible step to reduce and restrict the production. Because I think what employers are concerned with is that there's not going to be a subpoena issued to just ABC employer. It's going to be to like United Healthcare for all plan participant information. And so, just as one final note, my view is if you're going to take the time and energy to put together a travel lodging benefit, that it's also important to make sure that you protect that data, because you don't want to have, again, an aggressive attorney general coming in to try to get that data. And with that, I'll turn it back to Brittany.
Thank you, Erin. Thank you, Katie. That was a phenomenal presentation. We do have a couple of questions from our audience members, one specifically for Erin, and then one general question. So I'll start with the specific question to Erin. Have you seen any employer provide a tax-free contribution to an HSA for the cost of travel and lodging for medical care?
Not with an HSA, but I've seen both an HRA, a health reimbursement account, and I've also seen wellness programs where the participants have the ability to use those dollars for a variety of different possible benefits, including reproductive services.
And then one final question from audience member. So apparently there was an article about a doctor providing reproductive care by boat. Are there any potential tax issues raised by, I guess, what you could call a floating reproductive care clinic? Katie, this might be in your wheelhouse as well.
Actually, I think it's in Erin's.
Oh.
I don't know if you want to add maritime law to ERISA. That sounds complicated, but I think this is Erin's question.
Well, no, I do think it's interesting. It's this is admiralty law, right? Like the question is like, what state are you in? Are you in international waters? Are you? I mean, so I do think that we're gonna learn a lot, like I said, in the next 5 years about how the trajectory of this plays out. And so, like, where is that located? I think we'll all have to sort of put a pin in it and find out where we go.
Well, I think that is all the time we have. We are at 2:30, the end of the program. I want to extend a thank you to all of our panelists. I think we learned quite a bit about the tax and fetal personhood aspects of Dobbs. Again, I encourage everyone to join the tax section. For law students and JD and LLM students, it is free. And we hope to see you at future programs we have. Thank you all. And if you're interested in contacting us, we'll share the slides and our email addresses will be available in the slides. But thank you all and have a wonderful day.